Well, I called it a while back in an earlier video. The copyright lawsuit having to do with Top Gun Maverick, which claimed that the Top Gun sequel infringed the copyright in the article that inspired the original Top Gun movie, is no more. The judge granted summary judgment in favor of Paramount Pictures and found that there was no copyright infringement by Paramount and no breach of Paramount's license agreement with the author of the article. I'm going to talk about the reasons for the judge's ruling and what's important about it from an indie filmmaker's perspective. But first, just a couple of disclaimers, because we lawyers, as always, can't resist disclaiming things. First of all, what I'm about to tell you is not legal advice, because if I were going to give you legal advice, I would need to understand your specific situation and your specific needs. And right now, I'm just a random lawyer talking to you on the internet. And second, I'm going to be talking about issues of U.S. law. So if you're making your film outside the United States, or your production company is located outside the United States, then the legal concepts that I talk about in this video might not apply to you. Finally, if you found this video helpful, please like this video and subscribe to this channel so I can keep providing this kind of high-powered educational content to young, hungry, up-and-coming independent filmmakers like yourself. As I talked about earlier, the lawsuit was filed by the descendants of Ehud Yoneh, who wrote a 1983 article called Top Guns about the real-life Navy fighter weapons school, which is also known as Top Gun. Paramount signed a license agreement with Yoneh, in which Yoneh assigned Paramount the right to make a motion picture based on the article. In 1986, of course, Paramount released the original Top Gun movie and gave Yoneh a suggested by credit. In 2018, which was after Yoneh died, Yoneh's descendants terminated the license agreement. In 2022, Paramount, of course, released Top Gun Maverick, but didn't credit Yoneh. The Yoneys sued Paramount, claiming that Paramount breached the license agreement by not crediting Yoneh and infringed Yoneh's copyright in the article, which they now own because they were his descendants, and that was because elements of Top Gun Maverick were allegedly similar to aspects of the description of the Top Gun program in Yoneh's 1983 article. Paramount moved for summary judgment, which basically meant a motion to get rid of the case because there wasn't enough evidence to support the Yoneh's claims against Paramount. Last month, the court granted Paramount's motion. Why did the court make this ruling? I'll start by saying that to establish copyright infringement, you have to show that somebody else's work, that is their movie, their book, their song, or whatever, is substantially similar to yours. It's a bit of a vague legal concept, but the idea is that two works are substantially similar if enough elements in the allegedly infringing work are similar to elements in the allegedly infringed upon work. By an element, I mean, for example, the plot, characters, dialogue, or some other central aspect of the work. Another point to make about the law is that the elements that are shared by the two works in question have to be protected by the Copyright Act. Some elements of a book or movie or song or whatever are not protected. One example of this is that copyright law doesn't allow you to copyright facts. To illustrate what I mean, the Yoneys couldn't sue Paramount just for making a movie about the Navy Top Gun program, because the Top Gun program is something that actually exists out in the world and not something that Ehud Yoneh just made up for the purposes of his article. There are other aspects of a work that are not protected under copyright law. For example, stock themes, like an action hero who's a loose cannon and makes his own rules and is a man's man and so forth, like the Tom Cruise Maverick character himself. So the question in front of the court was, did Top Gun Maverick copy enough protected elements from Yoneh's article to be considered substantially similar for copyright law purposes? And the judge said no. To start with, the judge noted that, like I said earlier, although Yoneh's article and Top Gun Maverick were similar in that they were about the Top Gun school is real. And so making a movie about it can't be copyright infringement. Second, the judge noted that the themes that Top Gun Maverick allegedly copied from the article, like the bonds that form in military service, the sheer love of flying, and so on, are stock themes. And so they're not protected by copyright law either. Third, the movie's dialogue was not similar to the dialogue discussed in the article. The movie didn't repeat any of the statements attributed to the Navy pilots in Yoneh's article. Fourth, the setting of the article also was not copyrightable. The Yoneys pointed out that Top Gun Maverick takes place at a naval air station along the beach in Southern California, and the real-life pilots, who were discussed in Yoneh's article, were also training in Southern California. But again, the fact that the real-life Top Gun school was based in SoCal in the 80s is not copyrightable. Finally, as for the alleged breach of the requirement in the license agreement that Yoneh be credited, like I said, Top Gun Maverick was produced after Yoneh's descendants terminated the agreement in 2018. So the agreement didn't apply to the movie, which of course was made in 2022. So what guidance can we get from this ruling about producing independent film? Number one, if you make a film that's about historical facts, that doesn't mean that you'll violate the copyright of the people who were involved in those historical events, or of another person who may have written about them. That is, unless you take lines of dialogue from their story or their movie or something of that nature. That is, unless you copy protectable elements like we were talking about. If I make a movie about, for instance, former President Bush, Bush couldn't successfully sue me for copyright infringement. And no one who wrote a biography of him could do that either, because you can't copyright the historical events of George Bush's life. That is, again, unless I just lifted passages wholesale from somebody's book about Bush or something of that nature. And that brings me to an issue that I'm often asked about. That is whether you need a quote-unquote life story rights agreement to make a movie about somebody's life story. The law doesn't actually give a person life rights. That is, the right to prevent somebody from making a movie or writing a book about your life story. That's not to say that you can't have any liability for making a movie about somebody's life story. If, for instance, you say something about them in your film that's defamatory, that is, you make a false statement about them and they prove that your statement damaged their reputation, they could still sue you for what's called defamation. If you expose something private about them, like if I were making a documentary about former President Bush and I somehow got a hold of his medical records or naked photos of him or something like that, and I put that in my film, then I could be liable for something called public disclosure of private facts. But there are no life story rights per se. But back to this Top Gun Maverick order. The second observation I want to make about this order is that it shows us that cliches cannot be copyrighted. Themes that we've seen time and time again in movies and literature, like two young lovers whose families hate each other, a guy whose family gets killed and so he's out for revenge, a guy who develops superpowers from being irradiated, and so on, can't be copyrighted. So feel free to use those cliches in your indie film, as much as I would not like to see them get seen again. Copyright law is not going to stop you. So I hope this was helpful to you in understanding copyright law and how it interacts with independent film. And thanks very much for watching.